Hello, everyone, and thanks so much for joining us today. I know you'll be glad that you did. I thought this would be a terrific topic for one of our monthly free webinars, and I was right. We've had a great registration and a lot of interest in today's training. I'm Rita Wolfson. I am the founder of Financial Social Work and the Center for Financial Social Work. I'm also a national NASW pioneer and author, and a whole bunch of other wonderful things that I enjoy doing so very much. With us is Linda Benjamin, our relationship manager. Welcome, Linda. And
Thank you.
she will be helping us throughout the training. And our wonderful guest speaker, and you're going to have the opportunity to learn so much from her. I've learned so much from her, is Kathy Cooper Moran, and she will tell you more about herself when I turn this training over to her in a few minutes. We'll get started with some of the most commonly asked questions and some suggestions. Be sure to check the chat box for messages. None of our slides are shared. They are proprietary, but you will receive the recording, which will also be on our website, our Facebook page, and YouTube channel within a few days. You may type your questions into the question box all throughout the presentation, and we will answer as many as we possibly can. There is no CE for this webinar today. And if you have any technical issues, go ahead, you see that link for how to get help with those. And I want to encourage everyone to stay tuned, because this year we've been offering a special discount, and this one is special, to those who join us for our monthly free webinar. I'd like to start with our financial social work affirmation, because I feel it truly captures the essence of this work I've been doing for over 2 decades. Just for today, I will love myself enough to face my fears, practice self-acceptance, and embrace hope, silence my inner critic, speak my truth, and make peace with myself and with my past. Just for today, I give myself permission to eliminate toxic people, beliefs, and behaviors from my life. And just for today, I will prepare for a better tomorrow by healing my relationship with my money and with myself today. We like to get started then with a graphic that you can share your responses to. We call it an audience participation discussion. So tell us in the Q&A box, what does this graphic make you think of? Linda will share your responses, and we always have very fascinating responses, don't we, Linda?
We do. And I'm eager. Oh, money mindset. Money on the mind. Money on the brain. Oh, mind over money.
Oh.
Mind on my money and money on my mind. Financial overload. Money worries. Money on the mind. Stress responses to finance. Money worries. Financial overload. Good money management starts with the mind. Those are great responses. Thank you.
We really love doing this. We started it last year, and it's just much more fun for us than only doing polls. Okay, let's keep going. Before introducing our speaker and doing our training, I would like to tell you a little bit about financial social work so you understand why it is we do these monthly free webinars and what it is that we do. Financial social work is a behavioral model addressing the financial thoughts, feelings, attitudes, beliefs, values, and experiences that drive financial behavior. We do that because until and unless behavior changes, nothing changes. And for us, financial behavior incorporates how we earn, spend, save, share, and borrow. Money is complicated. Life is complicated. We know there is no one or easy solution or fix for either. What financial social work endeavors to do is to reduce the overwhelming feelings of stress, anxiety, shame, trauma, all the other issues that complicate money, life, and mental health. It's about healing your relationship with your money and yourself, growing more successful personally, financially, and professionally, taking control of your money to gain control of your life, making peace with your money and yourself, understanding there's always hope, setting personal and financial boundaries, reducing financial stress, anxiety, trauma, creating a safe, non-judgmental space to learn, process, and talk about money. It is about financial behavioral change. It is heart-centered. We approach finance from a perspective of healing, acceptance, courage, wellness, transparency, and honesty. You can see here that it is at the intersection of so many of the issues and categories that those of us in the helping professionals address. It's engaging, motivational, strength-based. It is a lot of different things. And at the core of the work is the essence. It's healing your relationship with money and your relationship with yourself and providing clients with that opportunity of self-discovery, self-care, and self-healing. It begins with the individual, expands to the family, the social environment, the workplace, and the community. We are fortunate enough to have graduates across this country and around the world. A simple truth is that no one chooses to have money problems, but unfortunately, most people do. That's why so many Americans need financial social work. It is a structural component of our profession. And as agents of change, we have a responsibility to modernize this profession to better serve the financial requirements of today's helping professionals. And our clients need trustworthy, reliable professionals with whom to process all things monetary. They need a safe, non-judgmental space where they may talk and learn about money. And one needs someone and somewhere to share their money secrets and questions, the ones they've been hiding from or avoiding all of their lives. So that is financial social work. And we have one quick poll before I turn this over to our presenter. And it is about which one of these applies to you. Okay. All right. 50% of you have voted. We always have a good response, and this is the only poll. So you're still sharing. And I'm just going to count it down 3 seconds. We're just about at 70% of you. And then I'm going to share the results with you. Okay. Thanks, everybody. We'll close that and share it. Okay. Well, for some reason, I can't see all the responses. But Kathy, if you see them, you can talk about them. I'm going to go ahead and hide that and turn this training over to our wonderful guest speaker. Here we go, Kathy.
Okay. So do you see my screen?
I do.
Think of that. I'm Kathy Moran. I'm a certified bankruptcy specialist, and I've practiced in the Northern District of California practiced bankruptcy law anyway, for 44 years. And I'm really tickled to connect with this group because I was telling Rita that I've been participating in a Facebook bankruptcy support group, and the amount of disinformation, anguish, and hopelessness that I see there, first of all, it's heartbreaking, and second of all, it's largely unnecessary. And so I'm hoping that by the end of this presentation, I will have empowered you to see bankruptcy as a possible tool for getting control of one's financial life. I don't think I have to convince this group that money is a source of stress. We live in a society that promotes relentlessly consumption, and there are no equally animated marketing campaigns for saving. It's always about spending. And we'd like to think that we're all middle class and we can all afford to live a middle class life, and that gets empowered or enabled for a while by the use of credit. The situation isn't helped by the fact that as a society, we are not open about money issues. We would rather talk about sex than our individual money situation. And we close off family money problems from our children, and we don't give them nearly a real world grip on what it means to live on a fixed income. And of course, the current situation's been exacerbated by COVID and inflation, and it's all tied back to the social disparities, the economic disparities of the society we live in. So that's our problem. I mean, that's the connection between bankruptcy and mental health, is that the tension created by the push to spend and to hold within oneself one's money troubles. I'm also appalled by the number of people, both my clients and the people I'm encountering on Facebook, who seem to be willing to accept making minimum monthly payments on impossible debt for as long as they live. And one of the things that, one of the reasons that escaping debt is important is that studies show that being in debt makes you stupid. You lose IQ points. And this is a study done cross-nationally. It's not just the US, it's also other countries. that you make poorer decisions when you're dealing with the stress of being in debt. And I'm sure you all see people who are living on the financial edge, people who fall within that group of what 40% of Americans couldn't meet a $400 emergency expense without borrowing. And as a result of, we have this ingrained sense that these are my debts and I want to pay them. I'm obligated. It's a moral imperative. And when that swamps a dollars and cents look at the situation, people neglect providing for retirement. I mean, the average Social Security check is about $1,700. And an enormous percentage of the American populace has next to nothing beyond Social Security for their old age. I have stopped talking to clients about preparing for retirement because the flip answer I get back is, I'm never going to retire. And sometimes it's because of interest and other times it's because of necessity. But we're all going to get old and we're living longer, and the fiction that we can keep working until we drop is the fiction. And of course, the stress compromises health. So there are just enormous objective reasons why getting out from under some of this debt is beneficial. And yet, the mistake that most of my clients make is that they wait far longer than they needed to or should have to file bankruptcy. Almost anybody who screws up their courage enough to sit down across the table from me, back when we sat across tables face to face, is almost assuredly someone who needs to consider bankruptcy. And yet they bring an enormous number, a collection of reasons that barriers to making that choice. One is the sense that they're going to be exposed to the community as having filed bankruptcy. And the number of people who ask me, will my name be published in the paper if I file? So I'd ask you, how many of you see a list in your local paper of people who filed bankruptcy? I would suspect in this day of diminished publications that not many papers devote any space to people who file bankruptcy. And the number of people who sit and read those, I think, is even fewer when they do get published. Bankruptcy is a matter of public record, particularly in this day of electronic filing. That information is there for anybody who really wants to dig to see who's filed. But how many of the people around you really care about who's filed bankruptcy? There seems to be an emotional cost of acquiescing to the fact that you're not going to be able to pay your debts. And people are quick to label themselves as failures for that reason. You know, another barrier to escaping debt is this fixation on credit scores. If there is anything that sends smoke steaming from my ears, it's this sense that one's self-worth is measured by your credit score. When credit scores are arbitrary products of commercial outfits, they're designed to measure risk in making loans, and yet they've been perverted and used for things that have nothing to do with financial responsibility, including pricing insurance and such. But it is utterly unhealthy for people to focus rather on their credit score. Objectively, credit scores bounce back pretty briskly when you file, but you can't convince a lot of the population that that's the case. I'm always urging people to look at their balance sheet. I think that's the number that makes a difference. Another barrier is this fear that bankruptcy is going to take everything from you, and which is absolutely not true. If for no other reason, then the only reason a bankruptcy trustee takes something from a debtor is if it has a monetary value that can be sold and realized and used to pay creditors. And this morning there was a post, somebody worried about losing their couch if they filed bankruptcy. Well, I can tell you that no couch that I've seen has any resale value, and no trustee is the least bit interested in taking things from people just because they have them. The trustee's focus is on gathering assets to pay creditors. So it's all a dollars and cents proposition. The other thing that I rant and rave about is this idea that's just bandied about much too loosely, that bankruptcy is the last resort, which kind of implies that you have to have tried everything else before you elect bankruptcy. I think that's the wrong way to look at the situation. There's no necessity to try and fail at inferior routes to getting rid of debt. Bankruptcy, it seems to me, is the big gun. And if your problems are big, that's the weapon to use to solve the problem, but it's not the last resort. And another barrier is the fear that's generated by creditors and some financial gurus who imply that life as you know it will end if you file bankruptcy. You'll never have credit for another 10 years, and your life is effectively over. And chief among the culprits there is Dave Ramsey, who himself filed bankruptcy, but has quite a following in preaching that bankruptcy is not an appropriate remedy. The why people file bankruptcy is not usually, irresponsible spending. Statistically, the drivers of bankruptcy tend to be job loss, ill health, divorce, and more recently here, business failure. I'm seeing a number of people who got EIDL loans during COVID that managed to prolong the life of struggling businesses, and we're now seeing that those businesses are hitting the wall. It's common for people to imagine that when they're sued, that they have to rush out and file bankruptcy on the spot, as if the reducing a debt to judgment made a difference. A judgment is just as dischargeable as the debt before the lawsuit was filed. The dischargeability, the legal forgiveness of that debt really looks at the nature of the debt and not its procedural standing. And then there are the people for whom bankruptcy is appropriate as a subjective matter. And I say to people, if worry about your debt gets in the way of, sleep, work, parenting, you need to consider bankruptcy. And you see that particularly in the elderly who tend to have imbued the sense that these are my debts and it's not honorable to discard them. So there's a place in bankruptcy for people who may be utterly protected by exemption law, and we'll talk about that in a little bit. And their Social Security is protected by law. There are other sources. Their homes may be protected by homestead exemptions, and yet the worry about money interferes with the quality of life. So there's a slice of people for whom, while objectively they're safe from creditors because they have nothing that's vulnerable, and yet they need it to get control of the stress in their heads. So let's talk a little bit about how bankruptcy works, or what it does. Bankruptcy is federal law, so it is universally available, and to the extent anything man-made is uniform, it's uniform across the country. The one place where bankruptcy differs from state to state is in the exemptions that are available to people who file. Exemptions are the assets or the financial value that is protected from creditors and from a bankruptcy trustee, so that you have something with which to use in your getting a fresh start in bankruptcy. And when the current bankruptcy code was enacted in 1978, Congress got real hung up on exemptions, largely because Southern legislators thought that the proposed federal bankruptcy exemptions were too generous. And so the states were given the option to opt out of the federal bankruptcy exemptions and make only the state exemptions available to their populace. So that's the one place that, on the face of it, bankruptcy differs. Otherwise, it's provided for in the Constitution that Congress has the power to make uniform bankruptcy laws. The feature of modern U.S. bankruptcy law is the automatic stay. And that's an injunction that issues immediately upon filing the case that prohibits creditors from taking any action against the debtor or the debtor's property to collect on an existing debt. So it brings lawsuits to a halt, it brings foreclosures to a halt, it terminates garnishments, and it's issued without any extra effort on the part of the debtor to get this protection. And the burden then of being relieved of that injunction falls to the creditor. So the burden is shifted from the debtor to the creditor. And the end product of bankruptcy, the goal in most cases, is the discharge. And the discharge is, the legal order that says that all dischargeable debts existing on the date the debtor filed are forever legally unenforceable. And then there are consequences if you try to enforce a discharge debt. It's important to recognize that the discharge only eliminates personal liability, but it does not alter liens. So the lien of a car loan remains unchanged. The mortgage and the right of the secured mortgage lender to his payments continue. Now, there are levers in bankruptcy that allow some judgment liens to be eliminated if they get in the way of an exemption that the debtor was otherwise entitled to. Chapter 13 is, well, let's say that there are, for most debtors, the choices are a Chapter 7 and a Chapter 13. 7 is denominated a liquidation, which contemplates that a trustee is empowered to gather up non-exempt assets of value and turn them into cash, and then distribute the funds according to the priorities that are in the bankruptcy code. And one of the lovely things about that priority list is that at the top of the list is back support. Support is not a debt that can be discharged. And then recent taxes are the kind of the next step down on the priority range. So instead of Visa getting a hunk of the money, the bankruptcy code priorities say we pay support first in full, and if there's money, then it goes down to looking at, are there recent taxes that are non-dischargeable that need to be paid? And only when those claims are paid in full do the general unsecured creditors get anything. Chapter 13 is a reorganization for an individual with a regular income. And it allows the debtor to remain in possession and control of their assets, and to propose a plan, generally to be funded out of future income, that gives creditors at least what they would have gotten had they filed a Chapter 7 instead. And that number looks at the asset value. The addition of the means test in 2005 kind of institutionalized the idea that the debtor has to make their best efforts to pay creditors over the life of a plan. There are huge advantages, in my view, to Chapter 13 for more complicated situations. It allows the continuation of a business. It facilitates a debtor catching up on back mortgage payments. It imposes a payment plan on the taxing authorities. And it is always dismissible at the debtor's election. Whereas if you file Chapter 7, you essentially are locked into a bankruptcy filing. In Chapter 13, you can say, this isn't working, or something unexpected has happened and I want out, and 13 allows that. back to dischargeable debts, the bankruptcy code starts from the proposition that all debts are dischargeable and then enumerates the exceptions. And the exceptions that are kind of statutory, that are fixed, are the exceptions for recent taxes, for drunk driving judgments, for family support, and for criminal restitution. And the list is longer, but they're more abstract and pretty specified, often financial fraud problems in business. And then there are three kinds of debts that might be non-dischargeable if the creditor affected brings an action in the bankruptcy court to proves up that the debtor incurred the debt by fraud or some other form of dishonesty, whether the debt arose in breach of fiduciary duty, embezzlement, and the third exception is essentially as intentional torts. The barroom brawl might be non-dischargeable if the creditor acts. And almost, it's hard to put I'm trying to think how recently in the last 10 years I've seen a non-dischargeability action. And I do essentially nothing other than bankruptcy. And I think I've tried one in the last 10 years. And if I represent a creditor, I always tell them that if your complaint is that the debtor lied, cheated, and stole before bankruptcy, your chances of recovering your money from somebody who lies, cheats, and steals after bankruptcy are not good. The discharge really is let's say it's objectively available. The anguish that I see again among the population is worry that if I took a vacation, if I bought something for my kids, if I fixed my car right before bankruptcy, is my case going to be thrown out? There is no subjective test about does the system approve of your financial choices. You can be as frivolous as you choose. The price of bankruptcy is honest disclosure. And make that disclosure and play straight with the system, which means listing your assets, listing your creditors, cooperating with the trustee if that's required, having some books and records that explain where your money's gone. Failure to do those things might get your discharge denied. But again, the incidence of that is very, very slight. And so for me, one of the appealing things about being a bankruptcy practitioner is that I can get clients financial relief that is predictable, almost certain, and reasonably quick by filing a bankruptcy case. Okay, so like anything that you don't master, there are all kinds of myths abounding about bankruptcy. And the other is almost on the myth category. is the sense that debt settlement, debt consolidation, or debt management are functional equivalents to bankruptcy, and they come close to scams, in my view, in that they prey on the desire of almost everybody I meet to pay their debts if they could. And they hold out this option that we'll settle your debts, we'll accumulate money, we'll make a deal with your creditors, and we'll take a slice of the money for ourselves too. And it simply seldom works. Creditors don't have to participate in a debt settlement program. They're predicated on not paying your debts until the creditor gets desperate enough to consider a settlement. Your credit score goes to hell in a handbasket, and you may well get sued. And yet those are the kinds of remedies, those are the kinds of deals that people will elect rather than think about using the law and bankruptcy to achieve some peace with their creditors. And, you know, the other myth that, well, one myth is certainly that only losers file bankruptcy. And there, first of all, that's nonsense. If you go back to thinking about the things that trigger bankruptcy: job loss, ill health, divorce, business failure. So I revisited the list of well-known people who have filed bankruptcy. We'll start with Walt Disney, Larry King, Thomas Jefferson, Tammy Wynette, Marvin Gaye, Henry Ford, Abe Lincoln, and then Dave Ramsey. And the list, of course, is much longer. And the other point that I try and make for clients is when you look at commercial bankruptcies, typically Chapter 11s, and you look at these big businesses that have huge budgets and experienced management who went to the best business schools around. And if those people can't make a go of a business and need to get reorganized in bankruptcy, why is it that you feel, with all the other things in your life, that you're a failure if you need the same relief? And there are other myths, but so I'd like to kind of enlist you all in helping consumers, families, understand that bankruptcy is an honorable and effective remedy for debt that you can't pay. And I'd like to work at lifting people's sight lines in terms of money from months to months to maybe decades to decades. That that if paying typically credit card debt is squeezing out having an emergency fund and setting aside money for old age, then your priorities are warped. That the part of being, you know, financially responsible is having those resources so that you can be independent. And I don't know of any old person who wants to be dependent in their old age on the goodwill of people around them. So I think one of the things I preach is that saving money for retirement is personally responsible and essential, unless you think you can live on $1,700 a month going forward. So that's my rant. And I'm hoping that you have questions that we can deal with, so that I can deliver what it is that you need that didn't make the presentation.
Well, that was wonderful. Thank you so much. I'm going to go ahead and take back the presentation so that we can, I have a few things to share, and then we can get right to Q&A. There are some things I'd like you to remember, and that's that no one chooses to have money problems, but most people do. And no one needs to know everything about money, but everyone needs to know certain things about money. And we have to stop allowing financial illiteracy to prevail, stop raising generations after generations of financially illiterate people. We want to always remain aware of the connection between money and mental health, and remember to always watch for the financial issues in all presenting problems, and make sure that clients don't consider suicide. We want to help clients heal the relationship with their money and themselves, and to remember that when we talk about money, we're talking about safety, security, survival, and we are talking about power, because those who have the money have the power. So we're going to just share a few additional resources, then tell you about our special discount for this month for those of you who were attending. Our next two free monthly webinars. June is building financial resilience in the LGBT community, and July is using financial wellness circles to heal money wounds. Just want you to know that we have a client financial wellness magazine on our website that you can share with your clients. We have a financial social work directory that you can register in. It's a resource for people searching for help and support in coping with today's many financial problems. We also have a partner program, and social workers and others have earned hundreds of dollars from our partner program. These are all on our website. We currently do have on change.org a petition. So if you are a social worker who wants to improve and support the professional recognition of social workers and address pay parity, you can still sign the petition, and we will be meeting together to address next steps. We also have the FSW Collaborative, and those meetings are for our students and graduates. The next one Shay will be doing, and that is mentoring. And then we have, they schedule, these are 4 amazing financial social work graduates who are very committed to this work. And on the 29th, we'll be having an open house, and they offer networking and mentorship and trainings. It's a great group. So the cost of our certification is $695. It includes those various things, plus 20 CEUs from National NASW. And for those of you who stayed with us today, we are offering a 15% discount on everything on our website. So copy down. The code is 2024-05. is the code for the discount. And there is a handout. If you look in that rectangular box, you can see handouts. And there's one in there. Kathy put together a really valuable and important listing of reliable, responsible resources on bankruptcy for you and those you know and your clients. So, Linda, do we have any questions?
We do, in fact, have a number of questions, and I will talk quickly to give Kathy plenty of time to respond. Our first question actually asks you, Kathy, are you an attorney or a certified bankruptcy counselor?
I'm an attorney. I'm a member of the State Bar of California, certified by the State Bar as a bankruptcy specialist.
Thank you so much. Like when we turn on the nightly news, we have lots of questions about student loans. Folks are asking, Kathy, how likely is it that someone with student loans can get them discharged through a Chapter 7 bankruptcy? Is there an income limit to qualify for Chapter 7 bankruptcy? We had a number of questions on student loans.
Okay, well, the student loan landscape has changed dramatically. I'm having some trouble with my voice here. In the last 18 months, the Department of Justice and the Department of Education have created some standards and a form that you fill out. If you're in a bankruptcy, you have to file an adversary proceeding to get the student loan discharged, and then fill out the Department of Justice's form. And the success rate on getting the department to agree to discharge the loans is very high, 70 to 80% right now. So the landscape has changed. And we're really looking at, factors for hardship. How long has the loan been out in payment status, age, income, family circumstances, employment. But it's different than it was. And then there are lots more administrative, non-bankruptcy ways that student loans can be discharged. So it's absolutely worth pursuing.
Well, that's very interesting. Thank you. Next
It
question.
is.
Yeah. Next question. When you work with clients who have very, very little money, are currently receiving just Social Security benefits, where would you refer them to get assistance to file for bankruptcy?
Well, some locales have legal aid that will do bankruptcies. That doesn't exist where I practice. Sometimes law schools have student clinics and students who have been admitted to practice provisionally in the courts. But I'm again back to, does that person really need bankruptcy, or is this a circumstance where the mental health aspects of need prevail over the objective thoughts that no creditor can get anything from them in any event?
Okay, thank you. Kathy, we also have someone who is interested in contacting you directly. Would you be willing to share?
I think my email address is at the bottom of the handout.
Okay. Okay, cool. Last question. I currently get spousal support from my ex-husband. Is that in peril, given that this person, my ex-husband, is filing for bankruptcy?
Not in the least. The state attorney generals did a bang-up job in 2005 of elevating support to the top of the distribution list. So, and support is one of those debts that is just simply flat out non-dischargeable in any form of bankruptcy. So there is zero chance that bankruptcy is going to eliminate your right to support.
Okay. We have two kind of particular questions, if that's okay to delve into. I'll start with the first one. I have a client, one of our participants writes, I have a client who owes around $65,000 in credit card debt and a car loan. However, she was told that she doesn't qualify for Chapter 7 bankruptcy due to income being too high. What would you recommend to do next?
I would recommend a second opinion. That seems to be a common misperception. The 2005 changes to the law introduced the means test, supposedly to assure uniformity of approach to the debtor's ability to pay, and to deny bankruptcy to somebody who had the ability to pay and wasn't willing to file Chapter 13. The first gate in the means test is whether a family is above or below the median income for a household of that size in their state. That is, and so if you are below median, end of discussion, you qualify for Chapter 7. If you are above median, then you go on to the second part of the means test, which analyzes that income and the demands on that income. And it's a complicated process, but it is fallacious to think that just because you're over median, you don't qualify. And given what I'm hearing online, I think that there are any number of people who are dispensing bad information about qualifying for bankruptcy. And if you truly have more income and have disposable income under the means test formula by the time you get to the bottom of the form, then you're a candidate for Chapter 13. And that number will influence what you pay over time to your creditors. But just because you're over median does not bar you from bankruptcy by any means.
Okay, got it. One more general question, and then if we have time for a specific one. To what extent does bankruptcy impact rental housing opportunities?
That's the hardest one for me to predict. When you think about the variety of landlords out there, from from the little old lady with the rental home to the big corporations with all kinds of rules, it's a factor. Objectively, you're somebody who has just filed bankruptcy is a better credit risk than somebody before they file bankruptcy. But it's a complicating factor, and it requires some shopping, and it may also require or it's facilitated by if you can put up a larger security deposit, if that's possible. Beyond that, it's hard to know.
Okay. We have one last person that's looking for some direction, and I hate to end before we give her some. She writes, my client is looking into bankruptcy, but they have a HELOC loan. Their goal is to keep the house, but they were told they'll lose the house if they file for bankruptcy with the existing HELOC. I wonder if they refinance and then pay in full and file bankruptcy after, if that would be realistic. She would just like some direction.
It's it's hard. There is no relationship that I can see between having a HELOC and losing the house. I mean, there are two ways that you lose the house. One is you don't pay the secured creditors and they foreclose. And the other is that you have so much equity over and above your exemption that that your creditors are entitled to a slice of that value. There's nothing about a HELOC itself that is disqualifying. So the question is, can you afford the payments, and is there any equity?
Right, right. And then Kathy, I simply want to share with you many, many thanks for this. And of course, one person had to jump off to vote early. So we count that as a good absence or a good early dismissal. Lots of interest, lots of great questions. What a wonderful presentation. Thank you so much.
You're welcome.
Kathy, thank you. I know you've helped so many people. It was terrific. And we hope to see you all back here next month. Thanks. Remember to take your handouts and stay well, everyone. Bye now.